Morning, everyone. Can everyone hear me and see me all right? Okay, perfect. So it's just gone 10 o'clock, so we'll get started. And then as we get late joiners, I can catch up, but it's also a recorded session. So if we lose any of you, that's fine. Just a quick welfare point. For those who are perceptive may notice that I am sporting a bit of a shyness or a black eye on my eye. It's nothing sinister. I was away on operational RNLI and Coast Guard duties last week in the Netherlands and had a bit of a boating accident, but I'm absolutely fine. But obviously, because this is video based, it's let's get the elephant in the room out the way. Anyways, so on to today's agenda, which is the Employment Rights Bill. So where are we now and what we need to do to prepare? So this is our biggest workplace law reform since 1996. So in almost 30 years, this is going to represent the biggest change to UK employment law rights. And if we're honest, the rights as they currently stand, they're not necessarily straightforward. People do make mistakes. We get them wrong. It's why our tribunals are so very busy. And it's about to get more complicated and also much, much easier for employees to enforce their rights. So this won't be the only session that we do on this. The reasons for that will become apparent as we go through the session. And whilst we're coming to the end of the parliamentary process for the Employment Rights Bill, there's still lots and lots of dark spots where we just don't have that detail yet because there needs to be secondary legislation. But what we are seeing in a much clearer fashion now, particularly with the Lords amendments being rejected and the bill now proceeding, that we're getting an idea of what the final shape of this bill is going to be, what those timescales are going to be, and also what we need to do to prepare. So with that, we'll get started, and we should have a bit of time at the end for some questions. As I say, the session is recorded and we are going to be providing the deck as well as some supporting materials as well to help you after the session. And of course, there will be future sessions on this topic as things become clearer still. So where are we now? So we've been through the parliamentary process. It's navigated quite a complex journey. So what we have in the UK is we have two chambers in Parliament. We have the House of Commons, House of Lords, and typically laws have to bounce between the two of them before we get to the bill in its final stages. Now, there's been lots of consultation within Parliament. There's been scrutiny committees looking at this text. There's been lots of amendments, particularly by the House of Lords. And what we saw last week is that most of those amendments were resoundingly rejected. Now, you may wonder, well, what was the point of it going to the Lords and going through that process? Well, one, it's our parliamentary process. Two, ordinarily and with previous parliaments, it could well be that other parties could have forced some of those amendments through, but because the Labour Party has such a majority, they're not really going to have a problem getting through the text in the format that they wanted. So most of the amendments, as I say, were rejected, including the provision by the House of Lords that they wanted that 2-year protected period where someone can be dismissed rather than removing it entirely and giving the day one rights. They were proposing a 6-month period instead, and that has been resoundingly rejected. So we are back to that day one rights position, which I'm going to come on to in more detail. So now it's cleared the Lords. We will have the final reading in the Houses of Commons, where it will then go to royal assent. The legislative process is paused here until mid-October because there's a scheduled break within Parliament. So royal assent is expected in mid to late October, following which we will then start to moving towards implementation. Now, what we don't want is anyone to panic. This does not mean that on the 1st of November, all of our law will change. The bill will become law, but there will be implementation dates, which means that certain provisions only come into force when they are scheduled. And where we've got these gaps, so where the Employment Rights Bill sets out a new provision or a new law, but then says that the detail will be provided in further regulations, those now need to be consulted on and drafted. So we're not going to see the full final form of our employment law probably into next year. The complexity this gives us is that this is going to be a very fluid and moving process, whereby month by month you will need to be aware of what laws are coming into force, what is going to change, and then what's coming next, so that you can plan for your business. Because there isn't just going to be a one-day deadline where everything changes. This is going to be very, very movable over the next 2 years. So timelines as we understand them at the moment: royal assent in October 2025. We're then looking at secondary legislation to commence drafting immediately, which is likely to take us into 2026, with then phased implementations across 2026 and 2027. We're expecting full compliance to be enforced by 2028. As we say, royal assent is imminent, but that implementation is going to be phased. And what we're expecting is that the most disruptive, likely being that day one rise, is going to be in the latter part of 2026. It's not something that we're going to be expecting to be happening in, for example, January, because there's a lot of further information that's going to be required from further legislation before we've got the full picture of that. So first of all, let's move on to 0 hours contracts and the reform that this is going to essentially present our businesses when it comes to rostering or setting rotas. So the key changes that are coming is that workers are going to gain the right to be given guaranteed hours based on the average hours that they have worked over a reference period. That's a lot of very vague wording. So let's break it down. They're going to have the right to be offered guaranteed hours. So as an employer, we are going to have to offer this guarantee. Now, what the House of Lords wanted to change is that the employee would have to ask for the guaranteed hours, and Labour have reversed that and said, no, it needs to be initiated by the employer, and there will be a deadline by which those hours have to be offered. What we don't yet know is what the reference period is going to be for sure. And we think this is what's going to come out in further regulations. So the way this would potentially work is, say that you have a 0 hours worker who works for you for 12 weeks. At the end of that 12-week period, if they trigger the right to the guaranteed hours, they will have the right for you to offer them guaranteed hours based on the average hours that they have worked during a period. And if that reference period is 6 weeks, 12 weeks, it will be the average of the hours that they have worked, and you would have to guarantee those hours going forward. Now, this is going to present issues for seasonal businesses. So, for example, if you are a hospitality business that is very, very busy during the summer months and your trade drops off and becomes very, very quiet once you get into September, we could be in the position where you've got someone who has got guaranteed high season hours as we move to out of season. Now, what we did see was an effort to move towards a further definition of worker, where we would have a seasonal worker. Essentially, what it looked like the Lord's trying to do was essentially carve out around seasonal work, and it doesn't look like that has been successful. So what we need to look out for here is what that reference period is going to be, and at what point those guaranteed hours are triggered. So this could very much impact how long you're prepared to take on 0 hours workers for, but also how many hours you're prepared to offer them. Because if you accidentally hit that tripwire and you have to guarantee their hours, you're going to want to mitigate your position as much as possible to make sure we're not having to offer too many hours during that guaranteed, once you hit that guarantee period. There's also going to be compensation if shifts are cancelled. So there will be the right to cancellation pay when not enough notice is given. And there will need to be reasonable notice given of shift changes and schedule modification. So it's going to very much reshape how we manage casual and flexible workers. And you're going to have to make sure that you have systems in place to be tracking hours, calculating entitlement, understanding who is coming up to the point where they've got to be offered guaranteed hours, what their average hours are going to be, making sure that you have a notification system in place should you need to change shifts, and that we're no longer just the day before a rota gets published, just filling the rota and thinking who can we get in tomorrow. We're going to have to be really, really planning how we are staffing our shifts and how we are using 0 hours workers. and whether actually it remains appropriate to use them. That's ultimately what this is doing, is making it essentially very, very difficult to take people on a 0 hours basis. So we've got a bit of a poll on the screen. So what we've asked here is: Employment Rights Bill introduces guaranteed hours, cancellation pay, and notice requirements for 0 hours workers. Which of these changes do you think will be the biggest challenge? So what we've got one answer in here so far. So the options we've got is tracking average hours and guaranteeing them, paying cancellation fees for short notice changes, meeting minimum notice for schedule changes, and none were already set up for this. So at the moment we're 50-50 on tracking hours, paying cancellation fees, a bit more now in tracking average hours. Yeah. Okay, yeah, so tracking average hours, that seems to be the one that's going to cause the biggest headache at the moment. And, particularly for businesses that do have either lots of 0 hours or where, things can change really, really quickly. I mean, I live somewhere that's very seasonal, and I know depending on, you can get up and it's raining, and there's some hospitality venues that have to close because of the weather. They don't get the luxury of notice before something changes. So there's going to be lots of planning that's required around this, but we are going to need that secondary legislation first to understand what the average reference periods are. Okay, next change: flexible working and statutory sick pay enhancements. So currently under flexible working, we have the right to request, and there's quite a broad employer discretion when it comes to how those are dealt with. It is a day one right, so people can request flexible working at the moment from day one of working. And at the moment, it's simply that right to request. And what we're going to see when we move on to the new regime is that the refusal from the employer, there's going to be a much higher burden that we need to meet here. So we can only refuse on the listed grounds, which we currently have already. So the 8 grounds, for those who are not sure on the reasons why you can lawfully refuse flexible working, is burden of additional costs, an inability to reorganise work amongst existing staff, inability to recruit additional staff where it would generate that need for additional staff, a detrimental impact on quality, a detrimental impact on performance, a detrimental impact on the ability to meet customer demand, that there's insufficient work at the period somebody wants to work, or that you've got planned structural changes for the business. So those 8 grounds are remaining in force. However, it must be reasonable for us to rely on those. So just giving the reason won't be enough. You will need to show that essentially you have looked at that request in detail, that you have analysed the reasons why your business can't accommodate it, and why your reasons are reasonable under one of those 8 reasons. So it's a much, much higher threshold for rejection. And the way that we're kind of wording this is the default is yes, unless you can give a really good lawful justification that is evidenced as to why it's a no. So it's really, really important that when we get to this stage of the changes, that if we are saying no, that we have good solid evidence as to why the business can't accommodate it under one of those 8 grounds. So it's likely we're going to see more successful requests. It's likely that we're going to see more litigation around this, and it's likely that your process is going to need to be very detailed, and you're going to need to know the operational side of your business inside and out, so that if somebody makes a request, that you can, in a very clear and evidenced way, explain why for your business operationally it's not going to work under one of those 8 reasons. This is going to be quite a technical area, I would say, because it's reliant on that reasonable test. So it's once this we get close to this coming in force, we'll probably do a session on flexible working in isolation. Then we've got statutory sick pay reform. So currently we have a 3-day waiting period. So if someone goes off sick, the first 3 days are unpaid, and they get statutory sick pay from day 4. And we have the lower earnings limit that applies. So if you have someone who's a very, very low earner, then they're not entitled to statutory sick pay. New regime, no waiting days, so they will get statutory sick pay from day 1. There will be no lower earnings limit threshold. So if someone falls below that, it's going to be based on their earnings, and that'll be capped at 80% of their average pay. So this isn't necessarily an increase in cost. I mean, SSP goes up every year. For people who are under that lower earnings limit, it doesn't mean that you're paying out more on statutory sick pay itself. It's just that there's more of your workforce that are going to be eligible for it. And obviously those three waiting days are where the additional cost is going to hit, because for someone who's off on a 4-day absence, rather than paying 1 day SSP, you're going to be paying for 4 days. So next, actually, before we move on, we've got another poll. So flexible working refusals must now be reasonable and on statutory grounds, and sick pay will be available from day one. Which of those reforms do you think is going to have the greatest day-to-day impact on your organisation? So more flexible working requests being approved, immediate sick pay entitlement for all workers, both equally or neither. Okay, interestingly, no one's saying neither, so everyone's going to feel the impact here somewhere, and both equally. Yeah. No, I think that's likely to be where we anticipated that one sitting. Okay, next, family leave and harassment protection reforms. So family leave expansion, it's removing the qualifying periods for various family-related leave entitlements. So currently there is a minimum service requirement before people are entitled to various aspects of family leave. We're going to see enhanced bereavement leave provisions and strengthened protection against detriment for taking family leave. So if somebody takes off leave under one of the family leave headings, that if they are put to a detriment for taking that leave, that there's going to be additional legal protection. So what we're seeing really is a new world where flexibility, work-life balance, and family commitments are very much more at the forefront. So the key here is, one, that they get immediate access to it. We don't have that kind of bedding in period with people when they join us, when we think, well, if something happens, if somebody either starts a family or they need access to time off, that we've got that kind of probation period where we're bedding them in, where we know that they're not going to be off, that someone could in effect have access to the leave from day one. So it's not necessarily an additional cost, it's just potentially disruptive. And we've got to be very, very careful, because on recruitment, we can't be asking questions around this sort of thing, or how likely someone is to take this sort of leave. One, because it starts us off on totally the wrong foot and the wrong approach with employees. But because of that enhanced statutory protection around detriment, you could be landing yourself in legal hot water if you were to be asking those questions. So what you need to make sure is that you are absolutely schooled up, one, on your policies around what your company offers around family leave and people's entitlements. And that also, we will be publishing tables on what the entitlements are, number of weeks, the pay they're entitled to, is make sure that you're familiar with those and that you have them to hand. So once we have that information, it will come out in a tabular form. And again, we'll probably do further training sessions specifically on this. There's lots of talk about expansion to paternity rights. So you may have read in the press, there's companies that are offering mirror benefits to men who go on paternity, essentially mirroring full statutory maternity entitlements. That isn't law, that's just companies that are doing that as an additional benefit at the moment. There is some lobbying going on to try and make that part of the law, but that has not been included in the Employment Rights Bill. So any changes around expansion of paternity to mirror maternity, we're not seeing yet under this legislation. Then got harassment NDAs. So we're going to have, as we currently do, the proactive duty to prevent sexual harassment in the workplace. There's the restoration of third-party harassment liability and restrictions on the use of non-disclosure agreements. Now, with us having last October, so a year ago now, that preventative duty, we're kind of used to that. So we're not really seeing an increase in threshold there. We have to proactively try and prevent sexual harassment in the workplace. That means that we have to do a risk assessment, we have to train people, we need to make third parties who come onto our premises aware that we have a zero tolerance policy, that we're very clear on our policies and it's all very visible. If all of this is sounding very strange to you and you don't know what I'm talking about, please book a demo with our training team, because we have a great e-learning package around prevention of sexual harassment and also training for employees, which is absolutely critical. And we've expanded our suite of training now to the point where we're able to offer bundles of training where, you know, you pay, it's one fee per employee and you get access to all of the training that we've got. So including anti-discrimination, anti-bullying. We're releasing health and safety soon, and a really great menopause course as well. So if none of what I just said about sexual harassment makes any sense to you, then please do drop us a line, and we can help sort you out with that. What is going to be the change here is the use of non-disclosure agreements around harassment. We're not going to be able to give people settlement agreements that carve out any claims for sexual harassment. So we are going to have to review our settlement agreement templates. If you've got someone who's made a sexual harassment allegation and we decide that we are going to offer that person either some money to drop a case or to leave the business, that settlement agreement won't be enforceable against a sexual harassment case. So we are going to have to just deal with these things. And what I have seen when I've talked to people about training their employees is that there is this kind of free use of settlement agreements and COT3s via ACAS to settle matters that they perceive to be difficult. Is we're going to lose the ability to do that. We've got to tackle this. We've got to train this behavior out of people. And actually, I've dealt with a matter recently for one of our clients, and they hadn't done the training. And when I was talking to the MD of the business, he said, well, I thought it was common sense that people knew what sexual harassment was and what's acceptable and what isn't. And it forms two purposes. One is we're educating people who actually don't know where the line is. But two, it gives you a defense as an employer to be able to say, we trained this person. They're not our problem. We taught them what the basic standard of behavior was, and this is not something that they've done within the course of their employment. So it's really, really crucial that, as much as we had to take it seriously last October, that this is now, because we don't have the ability to settle these claims once this comes in, it's going to be even more important that we have got that robust training regime in place. Unfair dismissal and trade union rights. Trade union stuff we are going to do an entirely different session on, because it's a bit niche for some businesses, so not everybody is facing this as an issue. There are going to be more businesses that are going to have issues with trade unions, because it's going to be much easier for recognition to come in, but we will do a separate session on that. What we're going to focus on at this point now, though, is the unfair dismissal threshold. So at the moment, someone has to work for you for 2 years before they have the right to bring an unfair dismissal claim, meaning essentially lots of businesses treat that 2-year period like a probation period. As long as we're not dismissing because someone's blown the whistle, raised a grievance, or something discriminatory has happened to them, we can dismiss in a very, very low risk way during those first 2 years. That is being entirely abolished, and someone who walks into your business on day one, if they are dismissed on day one of their employment, they will have the right to bring an unfair dismissal claim against you. Now, this is where we are going to need that secondary legislation, because what we are seeing is reference to a statutory probation period or an initial period of employment. We don't know how long that's going to be. It does look like there's going to be a slightly watered down regime to be able to dismiss people. So not the full-blown virtual test. So that we've got to have a fair reason, and we've got to have a reasonable belief in that reason after having done a reasonable investigation, and it's a reasonable outcome. So all the stuff that, if you ever take advice from me, you hear me witter on about all the time. We're hoping it's not going to be as odious as that. But again, we're not going to see what that looks like until we get the secondary legislation. But the key takeaway here is that it's a day one right. What I wouldn't be doing is obsessing too much over this statutory probation period or that watered down regime. The reality is, the world that you operate in as a business is changing. You will not just be able to dismiss somebody on day one of employment without going through a process and without having a fair reason. So it's going to be absolutely crucial that we nail down our recruitment processes, that we have a really good, robust way of working out who we are going to be working with. And that then when we have our probation periods, that we are being fair, that they are documented, that we are being organised about it, that we're setting expectations, that we are setting people up for success and supporting their performance, because we're going to have to evidence that we've done all of this correctly. And it's going to be really, really important that you work with really good, strong partners when it comes to recruitment. I hope she doesn't mind me saying I can see she's on the session today. So Kath Patterson, who is a recruitment expert and works very, very closely with businesses, almost on like a partner relationship to really help businesses get to grips with what they need and how to do things properly. Really, 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 great individual if recruitment is causing you a headache. And I'm more than happy, if she's happy for me to do so, to tag her in the LinkedIn stuff and the emails that go out after this, because having somebody like that on your team and available to you is really, really going to help when this comes into force. So new law versus the current law. Now, this slide is just a bit of a snapshot of a resource that we now have available, which is going to show you the area that's being reformed, the current law, new law, what your business impact will be, what steps we think you need to take, and also the timescales. Now, we couldn't get all of that on one screen, so if you want that as a resource, it's quite a lengthy document. We are going to maintain it and keep it up to date, but we're happy to circulate that so it gives you this snapshot of what it is that's coming, what to expect, and how you can get your business ready, so that when you're thinking about what it is that you're going to do, you've got that as kind of a bit of a guide. So I'm talking about programmatic compliance when I'm talking about the getting ready for the changes. So learning from things like GDPR and IR35 is taking a strategic and organization-wide approach to how we get ready for these changes. So there's going to be multiple reform areas that are going to affect every aspect of the employment life cycle, and there's lots of things that are interdependent. So they're going to hit lots of existing policies and systems and procedures in very complex ways, and we've got this staggered timing. So we need to think of this as a project-based approach. So my advice would be that you either set up a steering group. I mean, depending on the size of their business, that might just be a steering group of one. If anyone like me runs a small business where you're head of IT, head of welfare, head of absolutely everything, this could well just be that you're going to have to take on yourself. So that you're taking executive oversight and some strategic decisions over what's coming. So we need to be putting a plan together. So coordinating what it is that's going to be impacted, what policies we need to review, what timeline we're putting in place, how we're going to monitor our risk, and what it is that we're going to prioritize. Think about things like your HR operations, where you take your legal advice from, who is running your teams. So who is going to be responsible for making sure that they comply with these laws when they come into place, and are they trained and are they ready for this? Is your IT ready for it? Do you have systems in place that mean that you can update policies, that you can track performance, that you can make sure that the processes that you are doing are compliant? Is your finance team aware because of the changes around things like statutory sick pay, and how are we going to be communicating when policies change? Now, again, we when we started HRoes, we didn't know the Employment Rights Bill was coming, but actually in terms of our capabilities around things like changes to policies, keeping you consistent and compliant with the processes that you do, we're absolutely set up for that. So if you are thinking, right, with all these changes, I really now need to start looking at HR software and also maybe tag on a bit of consultancy and a bit of help, you know where we are. And then think about your work stream. So who is going to be responsible for each reform area? If your business is large enough that you can allocate a project, so for example, flexible working, 0 hours, day one rights, to individual people to start looking at those policies and to start thinking about, right, how are we going to prepare for this, and what changes do we need to implement, then I would suggest that, so that we don't get somebody who's totally overloaded. So I do an audit of your current state. So what have we got? Who have we got on what contracts? Who's on casual hours? Who is on full-time? Who's part-time? Who have we got on flexible working? Analyze your historical working patterns. So what hours are being worked and when? What are we staffing what shifts with which types of staff? So make sure you've got a really good picture of what your workforce looks like and how you staff your shifts. Think about then how you manage this day to day. Are you running off spreadsheets? Are you doing payroll in-house? What can you do to make your life easier? So can you outsource your payroll? Can you look at a HR system to track reference periods and work out what hours people are doing? What can you do around triggering reminders when it comes to those guaranteed hours coming up and at the point where we have to offer those guaranteed hours? And how we're going to have notifications in place around cancellation pay as well. making sure that before this comes into force, that we've got our updated policies and procedures ready, that we've trained line managers on how to run disciplinaries, how to run shifts, how to performance manage, how to onboard, how to take people through a probation period, and make sure that we are communicating these changes to the workforce as ready. Because what we don't want is at the top of the tree to be ready for all of this, and then we've got a line manager who has no idea that things have changed and runs a disciplinary off an old policy in the first 6 months of someone's employment and ends up getting us sued. On harassment, again, make sure you understand what's in your policies. Make sure that we redraft NDAs and any in-house settlement agreements that we might have. And please, 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 even if you don't use us, just train your staff. You need to make sure that we are getting this out of our cultures for everybody who comes on board your business to help keep that risk nice and low. In terms of onboarding and probation, so being visible of the day one rights, having a think about what your probation periods look like. Do you need to redesign them? Do you need to make them more supportive? Do we need to be better at tracking performance? Train your managers again, so it's not just a case of starting someone and then 6 months later failing someone's probation. That's probably not going to cut it under the new regime. And thinking about early warning systems as well. And again, this is something that we will be doing future sessions on in depth. So the roadmap, again, this is something that we will put out as part of the materials, but for the rest of this year, start thinking about how are we running our businesses, who's responsible for what, thinking about what do I know about my business, do I know enough about policies and who I've got working for me and how they're working. As we get into the latter stages of this year, start to think about what new policies could look like, maybe do a bit of shopping around for systems and start looking at your training programs and thinking about how we're going to communicate the changes. Once we start getting into next year, getting prepared for those go live dates, come on webcasts and sessions and make sure you know what's coming when and what you're on the hook for, so that by the time we're in 2027, we're really, really getting embedded with this and it starts to become part of our day-to-day working life. So your next steps, make sure that you assign dedicated owners. If you're a bit like me, that may well just be yourself, but have a think about who you have got and what skill sets you've got within your business that you can pull on some support. If this is something that you need external support from, this is something that we can also assist you with. Start doing your audits and thinking about shadow policies, so getting draft new policies ready. Monitor consultations, so set your news updates so you can see when the draft regulations are coming down the line and how they're being consulted on. We will keep people up to date as well, and make sure you get that training budgeted, planned in, and that you make sure that it's compulsory, particularly for line managers in these areas. So that brings us to the end of this session. Half an hour is quite limited when it comes to talking about so much change. Hopefully this has given you a bit of visibility around what's coming down the line and what needs to be done. I've got a quick question there. So how often is training required for sexual harassment? We suggest every year. One, because of skill fade, and if people aren't thinking about this stuff regularly, it means that they do forget some of the provisions. It's not necessarily as straightforward as we think, but it also means then that we're catching new joiners every year as well. If you need assistance, you know where we are. We do have our podcast. We're out recording this afternoon, our new sessions, and we are a top 20 UK podcast, actually number 14. We're very proud of. We bumped up the chart last week. So in there, we take client queries and issues, and we take them apart and tell you, how we would have dealt with things. And our suite of services, we have HR software, HR consultancy, and we also have e-learning. For those of you that are HR consultants or HR professionals, we do offer a white labeling option as well. So you can send out our e-learning as your own, and the same for the software as well. Now, what I haven't touched on that we will come on to in future sessions is the ID cards and what that's going to do around right to work and things like that. So there's kind of a pin in that at the moment because we don't know timescales. We don't know exactly what's going to happen with it. It's a change that's not coming out under the Employment Rights Bill. It's entirely different, but again, look out for future sessions on that as well. Dawn has dropped some links into the chat if you're interested in learning a bit more about our e-learning or the podcast, but that's it for today. So thank you so much, everybody, for joining us. I hope this has been useful for you. There will be in-depth, deep sessions on each of those key changes that we think are going to mostly impact the majority of businesses. once we get those regulations and we're a bit further down the timeline. So yeah, thank you very much, and I look forward to seeing you all on the next session.